afternoon. I'm Brad Gibbs. Welcome to another edition of Good Energy Talks. I'm here today with Professor Chris Kulander. And today we're going to talk a little bit about some federal cases, their implications on CCUS, where we think that might be headed in Texas, and then a little bit about some recent happenings in Oklahoma as well. So thank you again for joining us again, Chris. So first we're going to talk about the True Oil case, which is a case out of the Federal District Court of Wyoming. This is a case having to do with subsurface easements. And in that case, the issue there was whether a fee surface owner can grant a subsurface easement through federal minerals without BLM approval. Now, the reason this case is kind of interesting is because it has implications, broader implications for subsurface use generally. In Texas and many other places, the surface owner is thought to have a fairly unfettered right to grant subsurface use, whether it's a subsurface use agreement or pore space storage and various other uses. And in this case, at least, when federal minerals are involved, it seems that the BLM might have a right to request or require an APD be acquired before granting any type of subsurface rights. So this would be kind of a push back in the other direction. One of the reasons I thought this case was interesting is because it reminded me of a split of authority in Texas that's working its way up to the Supreme Court right now. In fact, it's pending before the Supreme Court, and that is the Myers Woodward case that was decided by the Corpus Christi Court of Appeals and the Mapco case out of Beaumont in the 90s. And I've invited Chris here today to tell us a little bit about these two cases.
Yes, well, in 91, we'll go back to that. The Mapco versus Carter case came out of the Beaumont Court of Appeals. And in that case, we were dealing with who owns the pore space inside salt. Well, what's that? Salt is considered to be a mineral, typically. And of course, as you know, if you've ever dissolved salt in anything, we all have, it makes, well, salty water. And you can make salt caverns by pumping in water and then pumping out the salt water, and the caverns inside the salt get bigger and bigger. The question arises then, who owns that pore space? Who owns those salt caverns? Is it the surface owner or is it the mineral owner? The general rule in Texas is that pore space, unless the severancing instrument says otherwise, pore space belongs to the surface owner. But the Carter case is interesting because it suggested that no, if the pore space is inside a mineral, if it's inside the salt, then the pore space belongs to the mineral owner. Fast forward to what? I think it was 2022. The court out of Corpus Christi said, in a rather harshly decided case, they said, no, we're just not going to, we don't believe that Beaumont decided that right. It doesn't matter if the pore space is inside a mineral salt. It belongs to the surface owner unless the severancing instrument says otherwise. And so it's one of these rare, that you see in the mineral realm anyways, splits between, in decisions between our Court of Appeals. So it'll be really interesting to see what the Texas Supreme Court says about Myers Woodward.
And if I recall correctly, one of the facts that are in dispute here, or one of the, I guess, issues is if you, as the salt extraction company, kind of create or make the salt caverns larger, then should you have some heightened right to use, lease, and kind of have more ownership over that pore space as opposed to just naturally existing pore space under the ground? Is that correct?
Right. It would seem like conceptually, as the pore spaces get bigger from pumping in water and then pumping out the salt water, as those pore spaces get bigger, the delta from the change in size from when it was to what you made it, you would seem like you'd have an argument that, well, that volume that we've increased it by, why wouldn't that belong to me? So I think this is ripe for a Texas Supreme Court case to come in, probably a long one, and they like to opine on these things, to explain where we're at in the state. And that really, I think, ties in with what's going on up in Wyoming on federal minerals. Now, in New Mexico, unless the severancing instrument says otherwise, pore space belongs to the surface owner by statute, not by case law.
And Texas conspicuously does not have a statute, at least currently, that directly addresses pore space ownership. But I think most commentators would agree that Texas appears to be trending towards, I believe, what's known as the American rule that says that the pore space is owned by the surface owner. Is that what you're kind of seeing emerging?
Yeah, there's a trend. It's definitely a minority view. You occasionally see it in the Appalachians, in places, maybe in Pennsylvania, where they have a number of different estates, like the Subsidence estate. But I would definitely say the majority view is, unless the severancing instrument provides otherwise, you can never forget that. Unless it provides otherwise, the surface owner owns the pore space.
And that's a great point. Parties are obviously free to agree to any ownership that they prefer, but these are default rules that you will see in the absence of an agreement. And of course, this is important because this empty space, these salt caverns, this pore space has a renewed value or a value that nobody really saw coming a few years ago. And this has to do with carbon sequestration, CCUS activities. Parties want to come in and inject and trap carbon in these pore spaces. And so suddenly there's a great deal of interest in who owns what and how these rights are eventually going to be parsed out. So kind of turning back to the federal context, there was a case a couple of years ago out of Oklahoma, the McGirt case, and I believe you wanted to chat a little bit about that today as well.
Yes, we don't have much federal or American Indian land here in Texas, but north of us there's a lot of tribal land and a fair amount of federal land in Oklahoma. Certainly west of us in New Mexico, an awful lot of federal and American Indian land there as well. The McGirt case was a closely decided 5-4 Texas Supreme Court case, which provided that ultimately that Congress was the one and only entity that could do away with American Indian reservations. Not the courts, not the state courts, certainly, and not the state legislature. And that opened the door, and again, a hotly contested 5-4 case of much of eastern Oklahoma still being under tribal authority. What's interesting about the McGirt case was it started off as a criminal case. There was a party who I believe was a tribal member that was charged with 3 serious crimes. It didn't come out in the case what they were, but the ultimate issue that came up in the Supreme Court was, is this reservation still around or not? It is. And why we care in the oil and gas context is because we have to ask ourselves if the in almost entire eastern part of Oklahoma is still considered to be a tribal reservation, does the state entity, the Oklahoma Corporation Commission, which is the Oklahoma version of the Railroad Commission or the Ohio Department of Natural Resources, does it have the authority to regulate on American Indian land? As a very general rule, state entities don't have the right to apply jurisdiction on federal land. That's the BIA, Bureau of Indian Affairs, through the Department of the Interior, the feds that do that. So that McGirt and how that ripples out and how the fact that it's a 5-4 case is really going to be an interesting thing to watch in the future.
So do you think that because that case was so narrowly decided that it will be potentially open for attack in the future?
I do. My experience with American Indian law, having gone to law school in Oklahoma at OU, is that it seems to be like a ship that just goes back and forth, and there'll be a very pro-broad Indian jurisdiction case, and then there'll be another case that narrows it considerably. And it's American Indian law and how it ties in with oil and gas law, obviously, because there's lots of oil and gas operations in these states that have American Indian reservations, is highly unpredictable. And it makes it difficult for operators and lenders out there.
Well, I appreciate your insight, and thank you for joining us today. We selected these cases today to highlight the fact that our firm does practice across a number of states. We practice on federal lands. We practice obviously in Texas, also Louisiana, where CCUS activity is really ramping up, particularly in light of the recent primacy that's been granted there that gives them the right to regulate that at the state level. We do our best to keep the industry at large educated on what's going on across the country, because not only do we find it to be of great deal of interest, but we also find that having sort of a national perspective makes us better oil and gas attorneys. So thank you very much for joining us today.